This is Bloomberg Law with June Grasso from Bloomberg Radio.
President Trump plunged the country into chaos, a cruel, nasty, and illegal chaos.
Senate Minority Leader Chuck Schumer said that after President Trump's Monday order freezing all federal grants, loans, and financial assistance, his office was flooded with calls from panicked people about programs that support everything from nonprofits to school boards to police departments. The blanket freeze caused mass confusion and chaos across the country, with the potential to disrupt a massive segment of federal spending that's relied on by local government, schools, and police departments. New York Attorney General Letitia James was one of 22 Democratic state AGs who sued the Trump administration on Tuesday.
Not only does this administration's new policy put people at risk, but it is plainly unconstitutional. The president does not get to decide which laws to enforce and for whom.
That same day, a federal judge in Washington temporarily halted the order. And then, in the most significant setback and the biggest about-face to date of the president's 10-day-old term, the White House rescinded the order today. Joining me is Alex Hontos, a partner at Dorsey Whitney and a former Justice Department attorney. Alex, how broad was the scope of this order?
So the OMB order issued on Monday by the administration was exceptionally broad, covering all forms of federal assistance with the exception of a few carve-outs in the order. So Medicare was carved out, for example, but notably Medicaid was not mentioned. So it covered, on its face, trillions of dollars of federal spending. That's about as broad as you can get.
In his first administration, Trump issued a Muslim travel ban, and it took 3 tries, 3 different versions, before it got approval from the Supreme Court. Is there a way for him to rewrite this and try again?
Well, I certainly expect that this will not be the end of the administration's efforts to, root out programs that it believes, should not be in federal spending, policies, procedures, that kind of thing. So I think they're going to try again. But what is striking about this is instead of targeting specific programs, they did a blanket pause. And, normally you would do a census of specific programs first, identify programs that were perhaps against your policy objectives, and then work those programs. And that's not the angle that they came at this from. They might change that, though, and we might see that next. And in fact, that's probably what is coming next.
So then they would actually have to do some work to figure that out.
Yes, that's right. So there is going to need to be a census, if you will, within the federal government for kind of a cataloging of the programs. And boy, are there a lot of them out there. Thousands of programs and offices and grants and contracts and things of that nature that will need to be assessed, analyzed, and then sort of reviewed for whether they're compliant or not compliant with the administration's objectives. So it's a Herculean effort.
So it will take a while.
It'll take a while. That's right.
Let's talk about the order itself and the problem with it. The legislative branch is supposed to be the one that decides where the money goes. Is that the basic problem?
That's one of the problems. That's right. So under the Constitution, the power of the purse, that is the legislative branch's purview, not the executive branch. The executive branch is supposed to execute the laws. Congress gets to dictate where funds are appropriated and stand up certain programs. So that is one of the fundamental challenges that the administration will have if it's trying to defend this kind of behavior in court. Courts are going to be asking questions about separation of powers and authority. There's also, lawyers in my space this week had to dust off the Impoundment Control Act of 1974 and kind of go back to the Nixon era and, look through the lens of whether the president has an authority issue when it comes to spending money that Congress has directed be spent. And certainly the legislative branch, Congress, believes that when it says to spend money, the president has to do that. And so there are a whole host, constitutional, statutory, of potential hurdles that the administration is really going to have to get around to effectuate this policy. And those are not even taking into account the political consequences of some of these actions. And you saw that occur, shortly after the OMB memo was issued, when red state governors, blue state governors were both howling about what this might mean for state budgets. Large for-profit clients of mine were very concerned about what this might mean for them. Higher education and university clients of mine were equally concerned. So you actually had a broad base of the American economy that really was concerned. So you have multiple challenges if you're the administration. One is a straight legal challenge, and that is a fraught area. And that will be played out in the courts, principally. But the other is a policy and kind of political issue related to this. And I think they bit off more than they can chew here in rolling this out in the way they did, because they certainly galvanized opposition in a incredibly fast way. I'm not so sure that the honeymoon for this administration is over, but it might be. And this might be the beginning of the end, at least, of the honeymoon for the administration.
How much discretion does a president have not to spend the money that's been appropriated by Congress? I mean, is that a settled issue?
Yeah, so it depends. The lawyer's favorite answer, right? So certain programs direct the expenditure of funds. If a statute directs the expenditure of funds, the president's ability to not spend those funds is significantly constrained. There can be some timing issues and that kind of thing where the president might have some flexibility. But if the president is directed to spend, that's weak ground for the president to try to defend and say, I don't have to spend. Now, in other types of programs where an appropriation is made, say, to an agency, the Defense Department, to further some general objective or innovation or something like that, where the Congress has not been crystal clear about who and what and why the expenditures will go out, the executive might claim to have more authority to have discretion to choose who gets those grant awards, for example, or contract awards. But there are still regulatory overlays that would apply even in that context as well. So while there is discretion at some level, it's cabined in many ways by statutes of general applicability. So on the government contract side, there's a Competition and Contracting Act, where basically competition for government contract awards is the general rule. Another example is the Administrative Procedures Act, where if the agency is going to do something and it falls within the purview of the APA, it has to do it in a certain way. Right? So you have these general statutes that may confine presidential and executive discretion. You have the specific statutes that may develop or create a particular program that would have limitations on presidential discretion. And you have both of those things that will be, I think, used by certainly adversaries of the administration's attempts, those affected by the administration's attempts to change grants or cancel grants, those things, they will be leveraged, and there will be arguments in court about whether in a given context or the issuance of a memo, perhaps, the president overstepped.
Other presidents have tried to get around this very issue before. Have any of them been successful?
I don't know that any other president has done what the president tried to do this week. And the idea of sort of stopping everything, which is a bit overblown, June, but not that much overblown. That, I can't think of a time when another president has tried to do that. I do think there's some interesting parallels, and I want to, think about a little bit during the Biden administration. The Biden administration somewhat famously tried to use federal contracts as a vehicle for policy objectives. So, a very common example is the federal contractor vaccine mandate, where the Biden administration was trying to require that anyone who was a federal contractor had to have a vaccinated workforce. Another example that President Biden tried was the government contractor minimum wage. Now, both of those efforts were attacked in the courts by constituencies, affected contractors, states that basically said the president lacked the authority to take those steps. And it was a bit of a mixed bag, but by and large, the courts agreed with those challenges and said that President Biden didn't have the authority to use sort of contractual terms with governmental counterparties, contractors, for example, to implement those policy objectives. That existing law did not allow him to go that far. And so I think you're going to see a lot of that authority that was used against President Biden's initiatives, or at least some of his initiatives, sort of turn back around now as a basis to challenge this and future efforts by the Trump administration to sort of do the same thing, but just to effectuate different policies.
During his campaign, he vowed to abolish the impoundment law altogether. So if he was able to do that, let's just say he's able to do that, he's able to get the votes, does that eliminate his problems here or not?
It doesn't eliminate his problems. He's got two problems on that. One is the statute itself, the impoundment statute itself. So he would have to get that repealed, which would require congressional action, or substantially changed. So that's a big if. But even if that could happen, June, you still have, and you will have deployed constitutional arguments that, fundamentally the power of the purse is a core legislative function. And the idea that the legislature appropriates funds and, decides how much is spent in the United States, that's pretty clear, I think, from the text of the Constitution. That's what that's about. And if it's possible for a president to accept the appropriation from Congress and just not spend it at all, that seems to significantly erode the constitutional protection afforded by the spending clause. And so I think there will be challenges to this, kind of regardless. I think you're going to see challenges raising statutory and constitutional challenges to the president's authority if that is something that he presses.
Thanks, Alex. That's Alex Hontos of Dorsey Whitney. Coming up next, the impact of Trump's executive order recognizing only two sexes. I'm June Grasso, and you're listening to Bloomberg.
It will henceforth be the official policy of the United States government that there are only two genders, male and female.
President Trump's order on day one, directing the federal government to recognize only two sexes, is bound to draw legal challenges, clashing with recent interpretations of a U.S. Supreme Court case that cemented anti-bias protections for LGBTQ+ workers. The Bostock v. Clayton County decision was the foundation for agency actions like the EEOC's harassment guidance addressing gender identity protections, which advises employers against misgendering and barring employees from using the bathrooms fitting the gender with which they identify. Trump's order addressing so-called gender ideology extremism is part of his broader push to roll back Biden-era diversity, equity, and inclusion policies. Joining me is David Lopez, a professor at Rutgers Law School and the former General Counsel for the EEOC under President Barack Obama. David, what does this order on only two sexes actually do? I mean, what does it direct the federal government to do?
Well, first of all, the executive order is just that. It's an executive order, so it can't change existing law, and it can't change, the Bostock decision. But it basically requires that the federal government act consistently with the order in terms of recognizing only two sexes and really erasing, transgender and other non-binary identities, right? And so that has, in turn, I think, cascaded through the federal government in terms of their actions, in terms of, even allowing individuals to identify their pronouns in their message signature. And then I think for an agency like EEOC, I think probably more damaging is that it really places front and center as a priority, to address issues related to the executive order. And of course, they cloak it all in the protection of women, but, basically the first statement of the acting chair of the EEOC was, basically identified, a couple priorities, sort of anti-DEI, and then sort of this issue of women being compelled, I guess, to go to restrooms with transgender individuals. And, certainly those are not anywhere near the top of the type of discrimination that folks see out in the field offices. It's just an ideologically driven agenda. So that has actual tangible material consequences.
So in the Biden administration policies, did they protect workers from misgendering and allow them to use bathrooms that aligned with their gender identity?
I mean, I think what's important to remember is that, Bostock came out a few years ago, and Bostock expressly ruled that the prohibition against sex discrimination embraced sexual orientation and gender identity, and that the courts have been sort of working that through. But I think in the interim, I think it's important to remember that the 11th Circuit, which is one of the most conservative circuits, ruled that misgendering someone deliberately over time does constitute harassment under Title VII. And then the 10th Circuit upheld a jury verdict, a very large jury verdict, and ruling by a jury in the Western District of Oklahoma, not necessarily regarded as, the most liberal part of the country, on behalf of a transgender professor who was denied tenure. And so what that illustrates to me is that when people look at the law and they look at the facts and the injustices that people are suffering based on gender identity, both the law and facts are on the side. So what the Biden administration did is, when it issues guidances, they don't invent stuff, right? They basically, what the policymakers do is they look at, hey, what have the courts decided? What are the issues out there? What's the logical reading of the U.S. Supreme Court's decision in Bostock? And that's what they include in the guidances, right? So again, an administrative agency like the EEOC, when it issues a guidance or it issues a technical assistance, they can't make the law. They don't make the law. They give basically their best, the agency's best interpretation of the law based on what the courts are doing, right? And they do that so that employers understand their responsibilities and employees understand the rights. And if an employer wants to contest it, they do all the time. Unfortunately, the EEOC guidances aren't always deferred to by the courts, and sometimes the courts, go against them completely, right? But what the EEOC is trying to do is it's trying to provide a mechanism for the good faith employers who don't want to discriminate.
The Biden administration EEOC policies, do they test the boundaries of the law, or were they clearly within what the courts have said?
Well, they're completely consistent with what the courts have said, right? And I think what's happening now is that this whole anti-transgender movement, they're looking for, kind of carve-outs to argue that what the Supreme Court said in Bostock, they really did not mean. Bostock is a decision that related directly to gender identity. The gender identity case was actually an EEOC case, the Harris Funeral Homes case, and there's really no language in there that kind of supports a carve-out. And so what's happening instead is it's sort of like this, political movement that is funded by millions and millions of dollars, and you saw it first in the campaign, and you continue to see it, that, really kind of attacks at its core, I think, what the Supreme Court did. And it's really, really important to remember that, the EEOC participated as amicus in several of the cases that addressed issues of sexual orientation and gender identity. As I mentioned, the gender identity case that went to the Supreme Court was the Harris Funeral Homes case, right? So that was one of the three that were part of the Bostock trilogy. And this happened at the beginning of the first Trump administration. The first Trump administration would not defend the EEOC position and actually switched sides at the Supreme Court and actually ended up on the losing side of the case. And I would also say, frankly, on the losing side of history and morality, right? So this is part of a consistent track record. And, right now what they're trying to do is by executive fiat, try to, almost like gaslight people into thinking that the law is what it's not. But you see these decisions, you see the Supreme Court, you see the 11th Circuit, you see the 10th Circuit that goes really in the opposite direction.
The EEOC, let's say, issues guidance under the Trump administration. Will the guidance itself be challenged in court?
Well, I mean, I think you saw, the guidance is, and, the guidance can mean different things. Guidance could be something, actually a policy guidance that's issued by the commission after a vote, or it could be, sort of a much more modest technical assistance that is issued by its Office of Legal Counsel. And so I think certainly in the Biden administration, you saw, really numerous challenges to both the harassment guidance, but also to the regulations under the Pregnancy Workers Fairness Act. So it's not uncommon to challenge the guidance in the courts. I mean, I think a lot of people have to ask about what the ultimate purpose is and the ultimate end game in terms of challenging the guidances, because what's going to happen is that the courts are going to just, look at the statute, look at the case law, and make their rulings based on that at the end of the day.
The Department of Justice is already backing off its defense of the EEOC in a lawsuit by 17 Republican-led states over its 2024 workplace harassment guidance. So that's the first example, I guess, of what the Trump administration intends to do?
Yeah, I mean, I think that's also consistent with the executive order. So, on one hand, an executive order cannot make law, but an executive order can basically direct the conduct of, I would say, cabinet-level agencies like the EEOC is kind of falling in line on this, or not the agency, but the acting chair of the EEOC is falling in line on this also. And I think that's what you can expect, right? I think that it's basically almost like throwing in the towel on this guidance. But the interesting thing is that given what I regard as unlawful terminations of Commissioners Charlotte Burrows and Jocelyn Samuels last night, the EEOC has left out a quorum. And that guidance is still good guidance, right? So we'll see how this plays out, right? But I think what's really important to remember, again, is that the Supreme Court has ruled. So, a lot of this sort of satellite litigation around the guidance and around the EEOC trying to give its best reading of the Supreme Court's decision and other court decisions across the country, at the end of the day, if the EEOC is turned into a zombie agency, or if the, Department of Justice Civil Rights Division has said that they're pausing all litigation and investigations, you have a private right of action. You have the private bar out there. People are still bringing cases under this. And I have faith in our federal courts. I tell my students, it's like, you're not going to love all of these decisions, and you're going to hate some of them, and some of them are going to just really piss you off, right? And, there's some judges that will often almost rule like they work for the administration. But I just think you only have to look at what the 11th Circuit did and what the 10th Circuit did, and about regular folks coming out in Oklahoma hearing the facts and saying, hey, what happened to this professor, that's an injustice. And not only is it an injustice, if you look at the jury verdict, they considered it an outrageous injustice, right? So I think when people hear the stories and hear the narratives, instead of, get kind of caught up in the gaslighting and the sort of right-wing media bubble, I think both the courts and the people respond consistent with the law and consistent with, I think, humanity.
Let me ask you one thing about Bostock. And this is a Supreme Court that has overturned precedent. Suppose a case involving misgendering or the bathroom use, whatever, comes before this Supreme Court. It's a different Supreme Court than heard the Bostock case. Will the Bostock case still be recognized as precedent?
I think they're going to affirm Bostock. I've been wrong before. I err on the side of glass half full, but I think Bostock is going to be okay. I mean, I think there may be some issues that come up with respect to religious exercise. But if you remember, in the Harris Funeral Homes case, they raised the Religious Freedom Restoration Act defense, and they were basically smacked down by the Sixth Circuit. And I think they recognized that this was kind of a road to nowhere, and they didn't raise it in the Supreme Court. And so, there certainly will be litigation in that area. But in terms of coming back and reversing Bostock, I'm hoping it doesn't happen. I actually haven't heard of the nefarious effort to do that, but you do hear about, these sort of carve-outs with respect to restroom usage or to the exercise of the employer's religious liberty. So I think there's certainly going to be more litigation, but I would hope that Bostock is safe. Bostock, you also have to understand the politics here is really the politics of punching down, because the transgender community is not particularly a large voting bloc, and they really depend on really raising their voices, but on the allyship of people of good conscience. But certainly Bostock was a historical decision with respect to sexual orientation. And, it was really an effort to kind of put the court on the right side of history. I don't see Bostock being reversed. I just think that it's an extremely popular decision.
Stay with me, David. Coming up next, Trump's unprecedented firing of 2 EEOC commissioners. You're listening to Bloomberg. President Donald Trump has fired 2 Democratic Equal Employment Opportunity Commission members in an unprecedented move that undercuts the Democrats' voting majority on the board. It leaves 2 seats on the 5-member Civil Rights Panel to be filed by nominations from the new administration. The firings contradict the historical precedent of leaving commissioners in place at the independent agency. Both have said they'll explore their legal options. I've been talking to David Lopez, a professor at Rutgers Law School and a former EEOC General Counsel. David, firing the commissioners is unprecedented, but is it illegal?
I suspect that this issue will be litigated, and I certainly believe that it's illegal. I worked with the commission, for several years, and, the commission was structured by Congress in 1964 as an independent agency, deliberately set apart from the different cabinet agencies and deliberately set apart from the sort of the whims of a particular executive's political moment, right? And it was structured as a bipartisan agency, so it would have diverse exchange of viewpoints. And the commissioners were given set terms because it was recognized that was important to maintain the independence of judgment of the agency. This is sort of kind of an overtly political move against 2, I think, extremely hardworking, intelligent, well-known civil rights advocates who were basically doing their job, right? I mean, they were basically doing their job, trying to educate the country about discrimination and opposing discriminatory practice. And so many people have said in the employment community, like, if this were a private sector case, this would be like a slam dunk because, clearly the motivation here was that they were opposing discriminatory practices. But I think, sort of separately, the structure of the agency is one of independence, and I actually regard this as illegal. And, if it's litigated, we'll see what the courts say. There are a couple other things, though, that are important to mention. One is, if it's tied up in litigation, what does that mean about a quorum for the commission? Without a quorum, it really hobbles the ability of the agency to do its work in all areas, right? In terms of approving the litigation, in terms of coming up with internal policies, in terms of addressing, complacent discrimination in the federal sector. It's really bad. And when you couple that with, I think the hiring freeze, and couple that with what I found to be an extremely serious first statement by the acting chair, which seemed to almost like mimic wholesale the Trump executive order, and thus suggesting like sort of an abandonment of like the independence of the agency. I think that there's perilous times.
I mean, is there really bipartisanship at the agency?
I will say, and I really think it's important for your listeners to know, and I think your listeners do know this, is that the whole bipartisanship and independence of that agency is built into the culture from top to bottom. And the agency has been through Democratic administrations and Republican administrations, but I think that, certainly the commitment of the civil servants goes back to sort of the original vision, and that is that civil rights is not a partisan issue, it's an American issue. And, I work under chairs and commissioners of a different party, and I know that when Chair Carrie Dominguez came in, one of the first things she did is she developed basically a program to address backlash discrimination against Arab and Muslims and people from South Asia. When Chair Naomi Earp came in, she really made an effort to reinvigorate the commission's focus on anti-Black racism, the original, catalyst for the commission. I worked with Vicki Lipnick for several years. We didn't agree on everything, maybe 50%, but, she cared about civil rights. She cared about the agency, and she certainly always, I think, carried out, I think, sort of the vision of Congress in terms of its independence, in terms of the bipartisan deliberation. And so, I think with the Trump administration, we find ourselves, in both administrations in a different world. It really, I think, cuts against the grain of what Congress is trying to do with this agency as part of this landmark Civil Rights Act. And it's a scary time, but, people are ready. I mean, people are going to push back. I mean, I think that's to be expected. And to sort of almost as a first statement to say that you're abandoning or not to mention at all the legacy and the sacrifice of people and the original catalyst in the civil rights movement for this agency, and to act to completely ignore the issue of anti-Black racism as well as gender and disability and age and everything else. I certainly could say that's not where the people I meet are. I worked at that agency many years, and, they valued its commitment to disability, to fight disability discrimination and age discrimination and sexual harassment, and the work on behalf of vulnerable workers. This just takes us to a completely very dystopian place, in my view.
So what would be the possible legal defenses the commissioners could raise to being fired by Trump? Is it precedent? Is it something else?
I think it's the language of the statute itself. I mean, you just have to look at the structure of the statute, and there's been a lot of litigation on independent agencies, but I think it's the structure of the statute itself.
The EEOC is one of several federal agencies facing lawsuits from challengers who argue that its leadership is unconstitutionally protected from being fired at will. I mean, does it fit in with other agencies, or does it stand apart for some reason?
Well, I mean, you have to look at all the agencies separately, and I know that there's ongoing litigation brought by basically Elon Musk and Jeff Bezos against the National Labor Relations Board, but all agencies function differently, right? Some agencies have, I think more defined adjudicatory functions. The EEOC, will engage in some adjudication with respect to, it's usually delegated with respect to the federal sector, but it's mostly, what it does is mostly policy, right? And I think what's important to remember here is that once the litigation is approved, the General Counsel has independent authority over that litigation. So, the sort of silver lining here is the litigation should go on. We'll see, but the litigation should go on that it already brought. I mean, every agency is different, so all of these cases that will come up or have been raised will, involve sort of a different factual scenario.
Do you think Trump is doing these firings just sort of shock and awe, or he really expects that this will, that it will take, that he'll be able to keep these two commissioners off?
I mean, I think it's a little broader than that, and I think you have to understand this in the context of gain litigation in the Civil Rights Division and in the context of basically gutting core functions of the OFCCP. Trump has never been accused of having a forward-looking vision, and this is a backward vision. I mean, this is an effort to kind of roll the clock back. This vision of civil rights agencies or civil rights itself as being infused with what, he would probably regard as identity politics, ignoring, the fact that these civil rights agencies have, become an engine of opportunity for workers across the country who have been, shut out because not only of race, but also because of sex, because of disability, because of age. And so in the effort to chase this sort of ideological phantasma of what he regards as sort of these, DEI programs run amok, or what he regards as sort of a radical gender ideology, he's not only wrong on those issues, but he ends up throwing out the baby with the bathwater. And I think this is by design. I don't think this is inadvertent. I think this is by design, and I think it's part of a broader kind of long-term plan to really gut government generally. So I don't think this is accidental. I mean, it's politics, because it's always politics, but it's also politics in service of kind of a backward-looking agenda. I don't know what the exact year is. I don't know if it's 1955 or if it's 1876. All the stuff he's doing, they got the civil service, which is based on merit, and replace those folks with political appointees, which by definition are not based on merit, seems to take us back to 1876, which is also the year that Reconstruction was gutted. So I don't know if the goal is to take us back to 1876, to the Gilded Age, or to take us back to 1963 before the Civil Rights Act was passed, or 1955 with the Eisenhower deportations. But, everything that's being done is about taking us backwards instead of addressing a changing and dynamic world and trying to ask ourselves, how can we use everybody's talents? How can we bring everybody on board? And so, more to come.
We are only 10 days into his second administration. Thanks so much for being on the show, David. That's Professor David Lopez of Rutgers Law School. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.